everybody, how are you? Welcome to the next instalment of the James Anderson webinar. I do hope you're all really well and enjoying this nice sunny morning. Thank you very much to Carol, who sent me a lovely email yesterday. I hope I answered your questions sufficiently, but some good questions there regarding your Section 21 notice and when to serve it and what to do with your deposit. So thank you very much for that, Carol. If you need any more advice, do feel free just to give me a call and I'll do my best to help, or send me an email and I can get back to you, no problem at all. So thank you for that. Today's webinar, we're just going to have a quick look at the updates to Housing Act notice periods that came into force right at the end of August. There have been some significant changes, and this affects your Section 21 and your Section 8 notices to tenants when you want to regain possession of your property. Of course, it's all COVID related and what's happening at the moment in the country. But let me just give you a little insight on what's changed and what it means for you as landlords, and of course for us as agents and our tenants. So I'll share my screen with you. We'll have a little look at some slides and hopefully they'll give you a good insight into what the changes are and where we stand now. Okay. So here we are. Now, there's been quite a few changes. The main thing is the length of notice period that is involved now with serving notice to your tenants. So let's begin with just a little review of this year. Sorry, beg your pardon. Here's your information, getting ahead of myself there. So if you want to find out a bit more and do a bit of research yourselves, you are very welcome to do that. We've got here a number of sites that you can look at. The main one we're talking about today, the Coronavirus Act 2020, Residential Tenancies, Protection from Eviction, Amendment, England, Regulations 2020. Quite a mouthful, that one. You've got your Section 21 forms, evicting tenants advice, Section 8 advice, and also just understanding the possession process, which is the one at the bottom there. So yeah, let's look at what's happened this year. So who remembers January? It was very different, wasn't it? Like a whole different world about 8 or 9 months ago. But in January, the notice period on a Section 21 notice, as you all probably know, was 2 months. If you wanted to gain possession of your property within the bounds of the contract, you gave a 2-month notice to your tenant on a Section 21 notice. So what happened next? The 26th of March rolled around, we all went into lockdown, and that 2-month notice then became a 3-month notice, okay? That was 26th of March. So that's been rolling on right up until recently. One thing that hasn't changed, mind you, and this is going to be old news to anybody that's watched some of these webinars, is the documentation that you need to provide to your tenant, and in order, provide that sufficiently and correctly, and your notice will be valid. So remember those documents: your gas certificate, your EPC, Energy Performance Certificate, your How to Rent guide, and the prescribed information regarding the deposit. So they all still stand, nothing's changed there. And if we don't serve those correctly, then that notice could well be invalid. Okay, like I said, that's old news to you guys, I'm sure. So then what happened in August? Okay, this was right at the end of August. It was Robert Jenrick up in Parliament, and very quickly and swiftly slipped through the Coronavirus 2020 legislation. And that was 28th of August. And on the 29th of August, it was announced that there were changes to the Housing Act notice period. So you can imagine us estate agents, and I imagine you landlords as well, that was a very quick bit of news. And we had about 24 hours to get ourselves into gear and make these changes and make sure we're on the right side of this new legislation and regulation. Okay, but we're used to that by now. The goalposts move all the time. So yeah, we're always on our toes at the moment. It's somewhat tiring, I will admit that, but it does keep things moving and exciting, if that's the right word. So these new changes, like I said, generally they're going to be 6 months in now, your notice periods, but this does apply to tenancies in England only. Scotland and Wales, they're doing their own thing, and I think they've already imposed these a little bit earlier than we have. But this is England only, which is where we're concerned. So Section 21 is a 6-month notice period, and Section 8 is now a 6-month notice period, but not all of them. It depends on the grounds that you're trying to seek possession by. But I will come to those. I'll explain that a bit further. Something you should know about the Section 21 notice is that it is now valid for 10 months. So you have your 6-month notice period, and then you have 4 months after that by which to start proceedings if you still need to remove your tenant. Bear in mind, this regulation applies to Housing Act tenancies only. So if you have a company let or a non-Housing Act let, then the 1 month notice period still applies. So bear that in mind if you are looking to serve notice and your tenant is a company, okay? And then finally, in addition to this new notice period regulation that we have, back in March, when that 3-month period was put into play, that was due to expire at the end of September. It was the 30th of September, which is next week. However, that has now changed, and this new regulation stands today, and it will run until the end of March in 2021. So this is going to continue until next spring, okay? I don't know if that will be the end of it. Probably won't. Things may get reduced, but who knows where we'll be in March. I hope we're in a much better place than we are at the moment. So I hope that's pretty straightforward for everybody. But what the question then comes up of, you know, what if you've served notice already? And, you know, what happens now? So you'll be glad to know that actually the new regulations aren't retrospective, which is a good thing to know, because that would make things very, very complicated with notices that have already been served earlier this year. So let's just have a look at what it actually means. So just starting on the left, so notice that was served before the 25th of March this year, the notice period does remain as 2 months under the Housing Act 1998. Okay, that's pretty straightforward. Now, 26th of March this year up to the 28th of August this year, notice periods are 3 months, and they remain at 3 months if notice was served in that period. And that's for your Section 8 and your Section 21 notices. Then finally, on the right-hand side, if notice was served between the 29th of August this year and then ongoing now until the 31st of March next year, this is where the notice periods are 6 months for your Section 8 and Section 21 notices, with some exceptions. Now, before we go on to the next slide, there was one thing I did want to mention, which was just being aware of serving those notices, especially around the 28th of August or 29th of August. If you did serve notice on a tenant around those dates, I would strongly advise you to double check those documents, double check when they actually arrived and the notice was deemed served. The reason I say this is because there was a bank holiday weekend. Obviously, postal serving of notice takes time, and it could arrive a day late perhaps. So do double check those. One thing that we do at James Anderson in terms of trying to make sure that those notices are served correctly, certainly your Section 21s, is that we hand deliver them through the tenant's door. And we take photos of that as well, literally taking a photo of that notice going through the letterbox. We do this 2 days prior to the service of notice to make sure that it arrives on time, and we do it before 4:30 p.m. on that day, because 4:30 p.m. is for want of a better phrase, close of business for serving your notices, okay? So before 4:30, and ideally 2 days before the notice starts. Again, if you want us to serve your Section 21 notice, we can do that. That is no problem at all. Section 8 notices are a bit different, and I would highly advise that you have a solicitor complete the Section 8 notices, especially where there are grounds involved. There might be more than one ground involved. That is for the legal people to do. We can do your Section 21s, but unfortunately, we are not lawyers. We're estate agents, yeah, I strongly advise you go to a solicitor for assistance on a Section 8 notice. Okay. Now, Section 8. Like I said, there's a bit more to it, a bit more complex. There are 17 or so grounds for possession in terms of getting your property back that you can cite. And of course, one of those is rent arrears, which at the moment is a bit of a hot potato for obvious reasons. And you know, we'll have a look at that, because that has changed quite significantly in terms of the notice period. Now, some of these grounds are they're separated into two parts. One of those is mandatory grounds. The second is discretionary grounds. So the mandatory grounds are where the grounds actually exist. There is the fault there from the tenant, and then the court has to grant possession to the landlord on the mandatory grounds if it's proven that the grounds exist. The discretionary grounds are slightly different. Those grounds could exist. However, the judge has that discretion to decide to grant or not to grant possession to the landlord. So you could, you know, there's an element of doubt there. Again, this is why you need a solicitor involved who knows all the little tweaks and the little tricks in order to make sure your case is successful. Oh, and by the way, the Section 8 notice now lasts for 12 months, okay? So let's have a little look at Section 8 and the grounds. Here are the mandatory grounds. I'll let you just have a little look at that for a moment and just take that in. So the first column on the left are your grounds 1 to 8. Second column is when to use them. So what's the reason for wanting to gain possession? The middle column there, the third column from the left, that was the original notice period as per the 1988 Housing Act, and the final column is where we stand today. Okay, these are the most recent changes on the far right hand side. So ground 1, owner occupation. You would like your property back so you can move in. Pretty straightforward. Most people will use a Section 21 notice for that. It is the same thing. You're asking for possession back. And yeah, so most people tend to use a Section 21 there rather than a Section 8. So if you have a look, grounds, you know, 1 to 6 there, all the way down to redevelopment, all now have a 6-month notice attached to them. Okay, so some of those have changed quite a lot in terms of the notice period. One other one on there which has changed, which again could happen at the moment with restrictions on travel, etc. What if you've got a tenant in your property where their right to rent has expired and they no longer have that right? That's changed from a 2-week notice to a 3-month notice. Okay, so here, this is where you've got these variations. It's not always 6 months. There are some that are slightly different. And then I guess probably the most important one at the moment, ground 8 at the bottom there, serious rent arrears. So previously, as I'm sure you're all familiar with, if your tenant was in 2 months rent arrears, then you could serve a Section 8 notice under ground 8, and that would be a 2-week notice. This has now changed. Have a look at the bottom of the far right-hand column. So if rent arrears are less than 6 months at the time of serving notice, then the notice period is 6 months. If rent arrears are more than 6 months at the time of serving notice, that is now a 4-week notice period, okay? So less than 6 months, 6-month notice. More than 6 months, it's only a 4-week notice. And I guess that's there to help those landlords who are in quite difficult situations and mounting up some serious rent arrears. So what about discretionary grounds? Let's have a look at those. And remember, these are the ones where the judge could decide one way or the other whether or not to grant possession of the property back to the landlord. Again, probably the most important ones here, grounds 10 and 11, second one down there, minor rent arrears and late payments. When we look at the far right hand side, it's exactly the same as ground 8 in terms of how you serve the notice, and depending on the amount of arrears will affect the amount of notice given. It's either going to be 6 months or 4 weeks, depending on those rent arrears, okay? Now, obviously, if you can cite and prove any of these other grounds, then you may have a case to gain possession back of your property. And there may be a number of grounds that you can cite as well. So they're not exclusive in any way. Obviously, one that is a slightly odd one, 14ZA, about halfway down, giving notice because the tenant's been convicted of a riot-related offence after the 13th of May 2014. Can't say I've ever come across that one before. I think the last riot in England was what, 2010, I think. But yeah, I really don't know how a landlord would come to find that information, to be quite honest. The other ground to look at is ground 14, antisocial behaviour, which has no notice at all, rather surprisingly. Okay, yeah, no notice, but I tell you what, that is probably going to be a very difficult one to prove. From what I understand, you know, you need witnesses, various statements against the tenant proving this antisocial behaviour, and there aren't many people who want to testify, because more often than not, there's a dispute between neighbours, and if you were up in court giving evidence against your next door neighbour, and the landlord didn't win that case, and the tenant remained in the property, you could imagine the atmosphere and the situation you may find yourself in with that neighbour having given evidence against them to remove them from the property. I can't imagine that would be a particularly amicable relationship, should we say. So yeah, you know, that's just a little insight into the discretionary grounds there. So yeah, like we said, they're in two parts, mandatory and discretionary. So, I mean, at this stage, you know, we're filling in pretty much paperwork and forms and getting a case together, but we're not yet in court. These are the notices that will get you to court, but actually in the journey, we're not there yet. So what is actually happening in the court at the moment? Because that's worth looking at. Because it's not a case of, you know, serving your notice, the notice expires and straight into court and off you go. That isn't the case at all at the moment, I'm afraid, ladies and gentlemen. So really what's happening is possession proceedings began again on the 21st of September, which was Monday this week. They have resumed, but they are subject to new court processes. And what that means is that they will include the prioritisation of cases. There's a working group that's been set up to identify the priorities here, but it will prioritise cases such as those involving antisocial behaviour and other crimes, extreme rent arrears, and also landlords who are in an awful situation and facing unmanageable debt as a result of rent arrears. Okay, now look, it's probably not going to happen particularly quickly. As far as I understand it, the figure is about 62,000 in terms of the cases that have built up since the courts went into moratorium and closed for a period. And you know, they're not going to be working back at full capacity by any means. I imagine that, you know, a county court probably sees, I don't know, half a dozen cases within an hour or so. I can imagine that's going to be cut right down just because of social distancing rules. You know, when I've been to court to help our landlords, there's usually lots and lots of people waiting around, waiting to be seen, waiting to be heard. and you just can't have that at the moment. So of course it's going to slow things down a bit. Again, that's going to knock on to timescales. You know, it's recommended an 8-week period for claims to be heard usually. That is going to go way beyond that, I think, at the moment. There is no figure, of course, but again, you'll just have to sit tight in that case. However, in order to help the situation, there are 10 new Nightingale courts that have been set up. You knew about the Nightingale hospitals to help those that fell sick, to help with the volume. It's the same with the courts. These courts have been set up to help with the volume of cases and to accelerate the system to try and push through as much as possible in the best possible time. And again, it's worth noting the government did also announce a winter truce whereby there will be no evictions permitted in the lead up to Christmas or over the Christmas period. So I think realistically, and what I hear, going around is that really, I can't really see any actual evictions happening until probably mid to late October at this rate. And that will probably take it up to maybe the end of November. And then obviously the winter truce kicks in over the Christmas period. So yeah, it's going to be an interesting situation for some of those landlords that are waiting to have their tenant evicted from the property. So there's also the element of what if you have a possession claim, already in the system, and you're waiting for that to come to life again and something to start happening. Now this is quite interesting. The date of the 3rd of August seems to be key here. To be honest, I'm not sure why the 3rd of August is the chosen date. I'm sure there is a good reason behind it that is beyond my research. But the 3rd of August seems to be the key date here. So really what's been said is that no cases from before the 3rd of August 2020 will immediately proceed to hearing, okay? But they will have to be reactivated by the landlord, and then they will be subject to a new review hearing, and that will take place at least 4 weeks before the substantive hearing, okay? So what's the reactivation part then? The reactivation notice, that's really got to include any information about how the tenant and their family members or any dependents have been affected by the COVID pandemic. You may remember across some of our webinars that we spoke about what you need to do if you are having rent arrears issues with your tenants, or you're not getting access for gas certificates, for example, which are a legal obligation. We talked about that, and it was all about keeping comprehensive records and an audit trail of everything that's taken place in terms of conversations, payments, expenses, all that sort of stuff. So this is what this includes, but also a more human side. You've got to provide information of how, COVID has affected the tenant and in turn affected you and the tenancy. And I guess it goes without saying that if the landlord is actually submitting a claim concerning rent arrears, there's got to be an up-to-date rent account for the last 2 years to be provided where applicable. And so therefore, both the reactivation notice and the how has the tenant been affected by COVID-19 information must be submitted, okay? If it's not submitted, then the court will adjourn the case until that information is provided by the landlord, okay? So that's going to be quite important for any case. What the courts have done is they've allowed 6 months for landlords to inform the court that they do wish to proceed and reactivate their existing cases. That deadline is 4 p.m. on the 29th of January 2021. If that deadline is not met, then what happens is the case becomes what's known as stayed, and the landlord will need to submit a formal application back to the courts in order to restore that case. Okay. And then finally, you know, if you are looking at multiple claims against your tenant, the reactivation notice must be submitted for each claim in this case. So that can be done with a simple covering letter. However, if you are going to do that, you've got to include the following. So you've got to include all issued and suspended cases using the case number. You've got to state the cases that you wish to continue and those that you wish to suspend or dismiss. And you must rank your cases in order of priority and importance. Okay. Now, hopefully, we're not in a situation where we need to do this. And at the moment, if you don't need to disturb your tenant and your tenancy, then I would leave it where it is and let it run. If you don't have any problems there and everything's ticking over okay, you know, if you're considering serving notice, maybe to sell the property or even to move back in yourself, do really consider that at the moment and the implications, because there's obviously it's going to take probably at least 6 months. It could take even longer if your tenant decides that they don't want to leave the property. Okay, so just bear that in mind if you're considering serving notice. But right now, a tenant paying rent and looking after the property is something to hold on to, I must say. Okay, so this is obviously if you've submitted your possession claim before the 3rd of August, this is what you need to work to. If it was after the 3rd of August, it's far more simple, okay? Really, what the courts have said is your case will be processed in due course, but you won't need to provide a reactivation notice, but you should provide information about the impact of coronavirus on your tenant, like we just mentioned. And again, if you do have a case in the system and you haven't provided this information, I urge you to do that as soon as possible. That is going to be really important to the success of your case, okay? And we wouldn't want any more delays than we're already facing. Right. So in terms of you know, the legal side, this is the pretty much the end of the webinar here. I wanted to try and make this as not necessarily watered down, but just simplified for everybody. If you want to research further, of course, there is the additional information that we saw on the first slides. And again, if you want to watch the video again to double check in the information, you're more than welcome to do that, and we will send the links out shortly. So yeah, I just hope that it just shows you where the landscape is at the moment regarding Section 21 and Section 8 notices particularly. And of course, like I've said throughout the webinar, this is not a sort of legally based webinar. This is just advice that I think is important for everybody to know and understand. So, you know, if you are looking at trying to serve notice on your tenant and you're not going down the Section 21 route, please make sure that you do enlist the help of a solicitor, because they will need to sign those Section 8 forms and make sure everything is done properly and ensure that your case is successful, okay? And then just finally, you know, this is where we stand today, and it's going to change. We've seen several changes already this year, and we are somewhat governed by you know, what we can't see, you know, in COVID and things like that. So bear with us. There's going to be more changes and updates and regulations that are going to be moving again, and I'll do my best to keep you updated and abreast of those as they happen. I mean, even this morning, I was looking through some articles, and all the opposition parties have, you know, piped up and are calling for the courts to go back into moratorium, you know, and to suspend evictions again for a further period of time as we enter into obviously the second phase of the pandemic. So it's probably going to change again, but bear with us. You know, we will do our best to make sure that you are looked after and that you have an understanding of what's going on with your tenancy and in the industry. So, you know, until next time, I'll bid you farewell. You know, continue to be kind, look after each other. Don't forget to wear your mask as well. And I hope to see you all again in about a month's time. So thank you, everybody. It's been a pleasure. Speak to you soon. Bye bye.